an intensive care unit doctor back in 2014, raising serious safety issues that are quite objective and verifiable, I have been absolutely astonished that it's taken 6 years to get the status of my 13 protected disclosures finally accepted as reasonable beliefs. What is even more astonishing is that £700,000 has been spent trying to undermine me as a person, as a doctor, and also, interestingly, my employment status, to try and stop the case being heard. And that was quite bad for me, but an excellent opportunity for crowdfunding, because I was able to demonstrate a key tactic in the litigation against me was to argue the nation's doctors out of whistleblowing protection. And as you can imagine, that's pretty scandalous, and was a great grounds to start a crowdfunding campaign, which has raised nearly £390,000 to help support my position. But yeah, as an intensive care unit doctor, raising something very verifiable about safety, and we all know how important intensive care units are now, perhaps particularly with the COVID-19 pandemic. It is astonishing how not only £700,000 has been spent in that way, but how it's been allowed to be spent in that way over 6 years. And I think,
and I understand you haven't even got to the facts, Chris, of the case. That this is all kind of 6 years. This has all come on technical arguments. So 6 years of technical arguments so far.
I mean, it's been a variety of tactics, but certainly 4 years was spent undermining my employment status to the extent that an employment tribunal was completely misled on how a doctor in this country was employed. And we have since, well, a Telegraph journalist has since found a hidden contract that wasn't disclosed that showed exactly how these 54,000 doctors were employed. And I just think as a doctor, I'm just shocked that A, that has gone on, and B, that it's been allowed to go on so long. And thankfully, it's starting to be discussed in the House of Commons, and Sir Norman Lamb has done some excellent work in that regard. And we've actually forced, and the word forced is important, the legal regulator to actually do its job and perform 3 separate investigations. And you know, as a doctor, I just find that all astonishing stuff. I had no idea that's how you would be treated after saying something fairly basic about something as important on intensive care, and an intensive care unit essentially serving 3 London boroughs.
I mean, when you blew the whistle and you raised these complaints, I mean, has it all panned out as you expected? What have been sort of the biggest surprises for you?
Well, I certainly would never have guessed I'd be 6 years. I think this sort of typifies it. 6 years on, it was me litigating in person against 3 QCs and 2 large law firms. And I would never have guessed that was where I would end up. But I think the tactics used against me I found very surprising. I think they come from the way the whistleblowing law is in the UK, and in particular how it is practiced in the employment tribunals. With me, that's involved trying to undermine the reasonableness of really quite basic, verifiable medical protective disclosures, which is a lot easier when you don't have a specialist tribunal of medics. Undermining, you know, me as a doctor and as a person, so that's mudslinging, much more understandable. And then I've already touched upon the undermining of my employment status, and that's 54,000 of my colleagues. And then lastly, you know, the threatening whilst under oath in Purda, being threatened for costs and my legal team for wasted costs. You know, these are all very surprising things to use against an intensive care doctor with an important case. And then lastly, bringing my wife into it, then being threatened for an entire day using cost threats to make an agreed statement and publish it to say the NHS acted in good faith. And, you know, my wife witnessed that herself. And then to have those methods denied by the NHS. You know, cost threats I get are a factor of adversarial litigation, but you can't have your cake and eat it. You know, once you go down that road, you kind of got to own the methodology that you sort of crush the junior doctor with cost threats. You can't sort of have it both ways. And the very fact I'm having this conversation as a about something as important as intensive care, I think is shocking, not just for me and my family, but should be for everybody. Coming back to that intensive care unit that serves 3 London boroughs during a coronavirus pandemic, these issues are even more understandable and important. And they're not my problem, you know, they're everybody's problem.
And because your complaint was specifically about understaffing of intensive care units, which has become more relevant than ever during times of COVID.
Well, yeah, I mean, we know that how much we need intensive care unit beds, and in particular during, you know, a respiratory viral pandemic. And in the UK, we're nowhere near a lot of other countries per capita ICU bed. So in these 2 London boroughs, they had it considerably worse than the rest of an already under ICU'd country. And it isn't just staffing, you know, the issues were about fundamental things in ICU, airway support, and they were linked to 2 deaths actually. And all of this has been, the employment tribunal had the wool pulled over their eyes, and at a huge cost to the taxpayer. And who do you think suffers from that? And it isn't just me and my family. I mean, it certainly is me and my family, but it's an important issue. And this sort of debate we're having today, I think is really important, because we need to move past the intentions of the Public Interest Disclosure Act. We're obviously very good intentions, and have a real look at how it plays out in practice. Because a case like mine, it's a waste of money, even if you don't get into the details. You know, who wants to spend £1 million crushing someone like me?
Chris, perhaps you could share a little bit about your experience with the regulator. So I know Paul mentioned regulators as being sort of weak and under-resourced.
Yeah, I mean, I would agree with Paul. And, you know, taking that context of my case, 6 years, £700,000 of public money, I think the legal regulator, the medical regulator, and the healthcare regulator have just run a mile from this case and making any kind of decisions. And I have some sympathy with anyone who's an employment judge or the employment tribunal system, because I think there is this reliance from the UK regulators on the employment tribunal system to investigate and test all these complex issues. And when they're specialist industries like health, finance, but, you know, in particular health in my case, there's this reliance on the litigant funding employment tribunal litigation to have these very often highly complex specialist issues dealt with. And let's face it, what that really means is regulators really, really holding on to the fact that there is every chance a claimant in a whistleblowing case will run out of time, energy or money, and no one will have to deal with anything.
I'd like to end this session just by inviting our guest speakers to give one top tip for those who advise senior executives whistleblowers on these issues, on how to overcome. So their top tip on how to overcome, you know, the current system, if that's possible to be done in a minute or so. I'll start with Chris. You're our real life whistleblower. I mean, what would be your sort of word of advice to someone who is thinking about blowing the whistle?
Make sure that you've discussed it with a variety of people, and whatever you say is robustly supported. I think there's a spectrum of the whistleblower acting in good faith. One being someone that legitimately believes something that many people might not agree with, and then the other end, somebody saying something very serious with serious evidence. Know where you are in that spectrum and take some advice on it before embarking on making a protected disclosure.
Early advice, thank you.